Greetings and good evening to one and all. I am Advocate Anand Kumar, practicing in Delhi High Court. I am going to be your host and the moderator for today's webinar. On behalf of my team, AP Legal Chambers, and on my personal behalf, I welcome you all to the 24th webinar of the series titled No Words to Say, The Prisoner's Rights and Freedom by our special speaker, Dr. Justice S Vimala Madam, former Judge, Madras High Court. I wholeheartedly welcome you, ma'am. Uh, I welcome all the participants. It is because of your continuous support and patronage that we are able to do our 24th webinar of the series. Before we start the session, I would like to make a few things clear. I request all the participants to kindly mute your audios and if possible, disable the videos too. The session is a completely moderated session, and once the presentation of our special speaker gets over, the APLC's APLC and the question answer session would be following. If you have any questions to ask our special speaker, you may kindly leave them in the chat box, and if time permits, all your questions will be answered by Madam. A brief introduction about our special speaker, Justice Dr. Justice S. Vimala Madam. She was born in 1957 and her education qualification includes BSc Chemistry and BL in Madras Law College and ML in Crimes and Tort and PhD in Law from Dr. Tamil Nadu Ambedkar Law College. She enrolled as an advocate and started practice in Chidambaram and Kadalur. In fact, she became the first judge of the Mahila Court in Chennai and in the year 2002. Aesthetically inclined, she got an award from Civic Exnora, Trichy, for keeping the district court clean and green, best state government office of 2005. She is the first ever woman to become the director of the State Judicial Academy in India in the year 2006. She introduced computer-aided teaching in the academy. During her tenure, she embarked on a mission to find out the ground realities and the problems faced by the inmates of the government vigilance homes, where the accused and the victims are put together. She submitted the findings to the High Court. Based on a report, the Honorable High Court, the then Chief Justice, directed the registry to file a public interest litigation that resulted in framing of exhaustive guidelines to the learned judicial magistrates dealing with the cases under ITP Act. This is hailed as a seminal contribution to the sensitization of an issue that would reform, rehabilitate, and reintegrate a considerable portion of the women folk, which hitherto unnoticed to the policy makers, social welfare organizations, and also to the judiciary itself. She has written a book, Whether Winning a Case Means Success in Life, which was published by the Tamil Nadu State Commission for Women. In the year 2010, she was invited by the UPSC to assist the interview board to screen the prospective deputy government counsel for the Indian Legal Service. After she became the Registrar General, the High Court of Madras on 6/2/2010, she had performed with typical vigor till her elevation to the bench of the Honorable Madras High Court. Under the directions of the Honorable Chief Justice, and she ensured a grand success of the inauguration of the 150th year celebration of the prestigious Madras High Court. She was appointed as the additional judge of the High Court on 2011, and she was made as the permanent judge on 2010-2013. She has decorated the prestigious Honorable Madras High Court and has also delivered lectures in the prominent academies across India, including National Judicial Academy, Bhopal, Delhi Judicial Academy, Karnataka State Judicial Academy, Police Training Academy in Chennai, Rajiv Gandhi Institute for Youth Development, Sriperumbudur, Madurai Kamarajar University, Annamalai University, Chidambaram, Dr. Ambedkar Law University, Chennai, Young Lawyers Empowerment Programs organized by the Bar Council of India. It gives immense pleasure and privilege to welcome our honorable speaker on board, and we are waiting to listen to your speech, madam. Thank you, and over to you.
Good evening to one and all. We are all meeting in a very, very important day, for which I thank AP Legal Chambers, especially Advocate Anand, who has been spending daytime as well as the night time to ensure that the program is organized well and the participants are given good information regarding the subject. He had been interacting with me regarding the topic also and the content to be presented. I was really impressed by the way in which this program is organized. Today, as you all know, is World Suicide Prevention Day. There was also a webinar in the afternoon organized by Chellamathu Trust at Madurai, and there is one more program in the night also. To that extent, the topic of suicide prevention is gaining importance. When we talk of suicide prevention, naturally the prisoners will be the first group that will be coming to our mind, and therefore it will be an unforgettable day that we are all together in a very important day where we will be talking about the prevention of suicide inside prisons also. First of all, I would like to know how many of them are of the view that there are more important topics than this to talk about, and that this topic is of less importance. What are their views and comments on that? Only one or two views, that will be enough.
This is really important. It is of no less importance.
No less important. I am really happy to hear that comment. Yes, comments and yes, many of you would have this case law is very, very familiar to every one of you. It is Sunil Patra versus Delhi administration, where Honorable Justice Krishna Iyer has spoken about the problems of prisoners, and which will in turn give you an insight as to why we should talk about prisoners' rights. I'll just, the very important paragraph that I have extracted here. Prisoners are peculiarly and doubly handicapped. They live in poverty, lack literacy, judged by social station. The prison house is your walled-off word. I want all of you to underline in your mind this phrase, walled-off world, which is incommunicado for the human world. This singular sentence, the prison house is a walled-off world which is incommunicado for the human world. The bonded inmates are invisible, their voices inaudible, their injustices unheeded. So it is imperative, as implicit in Article 21, that life or liberty shall not be kept in suspended animation or congealed into animal existence without the fresh flow of air. I think no better words could express this kind of problems of prisoners. Nobody would have felt the extreme of the problems of the prisoners. When the inmates become an invisible persons and the voices are inaudible, the grievances are unaired, then it is our imperative duty to learn about the problems of prisoners. My endeavor would be not to enlist all the rights that are available to the prisoners, but to make you think about their problems, possible problems and possible solutions. When the whole world was thinking about the slavery and the ultimate freedom, many of our leaders fought for the freedom. And while they fought for freedom, they wanted to go inside the prison despite knowing that what kind of prison life it would be. I think many of you would have visited Andaman Nicobar. When I visited Andaman Nicobar, I was so thrilled by the nature there and the bluish water that seems to be merging with the sky. That is a kind of feeling I had. But everything, all my happiness went off when I visited and saw the Andaman jail. It is so pitiable that in the night one can stand and one cannot even sit, and there is no question of lying down inside the prison. That is the kind of prison life our leaders have undergone for the purpose of liberating us and giving us freedom. My question is, after getting freedom, if people are going to be like slaves inside the prison, for what we obtained freedom? That is the very primary question that was running in my mind. That is one part of it. And the second part of it is, during COVID-19, that this the entire world is now under bondage. Nobody has feel the freedom to come out of the house. I think inside the house, majority of us, at least those who are attending this webinar, would be having at least the fundamental facilities. Despite having all the facilities, when we have no freedom to go out of the house, how we felt. Quite often I was reminded of the prisoners who were continuously inside the prison without having liberty, not even to take food as they wanted, not even at the time when they want to come out, they can't come out. I was reminded of those kind of prisoners. For a moment, nobody need to think that those who have committed some kind of sin is so kind of legal injury. Those who have violated law are supposed to undergo this kind of inconveniences. Not that. Prisoners are sent to prison only as a measure of punishment and not to have any more further punishment inside the prison. That is what I want to submit before all of you. For the crime already committed, the court imposes some kind of punishment. Yes, they cannot have the liberty like any other persons, but at the same time, they cannot be allowed to suffer any more than the sentence imposed by the court. You know, all of you know that our prisons are overcrowded but understaffed. There is no training for those kind of persons who are employed in prisons, and they practically treat all the prisoners like chattel, and therefore all the prisoners have their own grievances. The next question would be whether these prisoners have some kind of grievance mechanism. Immediately you will think of legal aid, you will think of grievance box, and so many other things that will come to our mind. But how far, despite the availability of the provisions for redress mechanism, how far it is implemented? Implementation is one thing, existence of facility or provision is one more thing. Yes, it is. There are provisions, but when it comes to a question of implementation, it is very, very difficult. Then we will just go through the history of one or two leaders who volunteered to get the prison sentence, and thus those who are fighting for liberation. Then we will go to the prisoners' rights. I think many of us would have come across the biography of Oscar Wilde. Oscar Wilde is a very interesting and an impressive writer. Whenever his play or his screenplay is played in London theatres, there will be overcrowding even at that point of time. He was such a familiar person and such a good writer. But he got entangled in a crime of homosexuality. Homosexuality was an offense at that point of time. His friends advised him to go to another country where the homosexuality is not an offense, but he was not agreeable for that. He wanted to face the consequences, so therefore he was subjected to trial, and ultimately he was sentenced to 2 years imprisonment. At that kind of sufferings inside the prison, and the subsequent consequences upon his life, he died even before completing the age of 50. He wrote many poems about the prison life, and one such poem is this: I know not whether the laws be right or whether the laws be wrong. All that we know who lie in jail is that the wall is strong, and that each day is like a year. I repeat, each day is like a year whose days are long. You just imagine, in a year, Each day is look like an year, and in a year each day is long. See the kind of suffering that one undergoes inside the prison. The prison wall is strong in the sense that it is walled off from the whole world and no sound reaches. We do not know what is happening inside the wall. That is said, that is how it is said, the wall appears to be strong for a prisoner. Oh, I'm repeating once again, some of you might be thinking that at least some kind of inconveniences one must suffer so that they realize the benefits of freedom. Yes, it is true, but the unwarranted treatment, unwanted restrictions, treating them not like a human being at all, makes us to distinguish between the kinds of prisoners. There are several kinds of prisoners, as we all know. They are under trial prisoners, number one. Number two, convicted prisoners. Number three, political prisoners. And even among convicted prisoners and under trial prisoners, many of the prisoners would be entangled themselves in a family dispute. We know after the introduction of section 498A, 306, 304B, and all other matrimonial offences, quite often family members got entangled, and many of them became there is increase in the women prisoners only on account of the family disputes coming to the court. When these kind of prisoners are there inside the jail, and what kind of feeling that you will be giving? No doubt our law says that reformation is important and reformation is the ultimate goal and aim, but when we are not treating them well, what would be their feeling and how they would get reformed inside the jail? And if we only convicted persons are there, convicted persons will be mending their thoughts and ways. If we are going to punish the innocents and putting them inside the jail, can we expect any reformation? Definitely no. We can't expect any reformation. We can expect only revolt, and they will become the persons who will be again committing crime after coming out of that. Therefore, it is all the more important that we should be concerned about the rights of the prisoners. All rights that are provided under the Constitution to all the human beings as fundamental human rights are applicable to the prisoners also, less the freedom that is taken away by the court, by a legal process, by a competent forum in a legal way. All fundamental rights, less the rights that are legally taken away in a procedural format. That is all about the definition of a prisoner. Now coming back to Oscar Wilde, on 25th May 1895, Oscar Wilde was taken to prison. He spent several months in London prison where he was put to work picking oakum. This is a kind of work he was doing that we are not concerned with. He spent the last 3 years of his life in exile in France, where he composed the Ballad of Reading Gaol. I have just put it all these things because I want you to read. Whomsoever is interested in literature, whomsoever is interested in prison life, please go through this Ballad of Reading Gaol. It is very, very impressive and very, very apt, very particularly, very crystallized way the prison life is exhibited there. I would tell you why I am going in this line instead of talking about the case law. Case laws are you can just go through, and the case history everyone knows. But I am more particular about this kind of incidents, histories, expressions, feelings, etc., etc. This will have its own history. This poem, which I like, and I used to read this kind of poems in respect of all other matters also. There was a girl who was, at the time of advocates boycott, she was pregnant, and she came and wanted a parole for her husband. And she was also telling that parole is required not only at the time of her delivery, but also at least 10 days prior to that, because she was telling she is not able to sleep because of the pregnancy, and her husband's release just at least before 10 days of her delivery would give her a peaceful sleeping time. At that point of time, this poem was quoted. I know that that is a different thing, but this poem was also quoted saying that this is the kind of life that the one they have in the prison life. And in the interest of them also, at least they should breathe the fresh air at least for few days so that they can go rejuvenated back. And this kind of the way in which the problem undergone by the prisoner is expressed make us feel that yes, they are also human beings, yes, they are also entitled to certain rights, and we must think over all these rights. Only for that purpose it is there. Among all creations of the nature, human beings are the best part of the creations. And in India especially, we have the social system which is based on non-violence, a legal system which is based on rule of law, and the judicial system which is based on not only on law but also on the common law principle of justice, equity, and good conscience. And the fight for human rights have a long checkered history, like American Revolution and French Revolution, etc., etc. Our leaders, so far as India is concerned, who was mainly taking part in the Indian freedom struggle, as we all know, is Mahatma Gandhi. You might remember that when he was facing trial, what was his argument before the court? He was bold enough to say that, yes, I did this kind of revolution. I only wanted my people to participate. I'm not going to deny that. And if as a judge, if you say that when I fought for my country, it is a crime, you give me the maximum punishment. That was his plea before the court. You imagine what kind of plea it is. You give me the maximum sentence. That is what he pleaded. Like our Mahatma Gandhi ji, it is one more who was thinking mostly about the people, and he was also having the courage to say that I must be sentenced for the crime. If the court is going to say that fighting the battle for the freedom of a country is also an offense. Why I am putting this, the definition of people by Fidel Castro, is that we also have the similar phrase, we the people of India, in the constitutional preambular portion. We the people, Honorable Justice Krishna Iyer has used this phrase, we the people of India, in several judgments. And I thought that this definition by Fidel Castro is very, very interesting. This is what it reads. When we talk about the people, we are not referring to the well-off and conservative sectors of the nation for whom any repressive regime, any dictatorship, any despotism is convenient, who kneel before whichever master. What we understand by the people when we speak of the struggle is the great unredeemed mass who get cheated and betrayed, who long for a better, more dignified, more just homeland, who are moved by an ancestral thirst for justice. I repeat, ancestral thirst for justice, because they have suffered injustice and have been mocked generation after generation. See the kind of people which the leaders have thought about. Even after independence, even after the Constitution of India, which prescribes mandatory duty upon us to consider the plight of those persons, it is our duty to consider the special need of those kind of people who always remain oppressed and suppressed. This is the statement of Mahatma Gandhi, which I have been referring to. Inflict on me the severest penalty. That was his plea, and later on he was also sentenced, and that is a history, or you all know about that. Bhagat Singh was also executed by the British after a sham trial for his involvement in Lahore conspiracy case at the age of 23. I think many of you would have known the history about Bhagat Singh. And there are so many leaders like them, not only these three, and there are several other leaders who fought for them because we should have real freedom, freedom in real sense of the term, not the mockery of freedom that is happening here. And why we are concerned with the prisoners, right? There is one more reason for that. That is the principle of presumption of innocence. Our law presumes that a person accused of is presumed to be innocent unless proven guilty. I'm emphasizing this statement because many of the prisoners inside the jail are under trials. In other words, under trial prisoners are more than convicted prisoners. If there is presumption of innocence, what is the justification for keeping those under trial prisoners inside? On one side, we say that they are presumed to be innocent. On other side, we say that speedy trial is their fundamental right. Still, we keep them inside without any progress in the trial. That is what is unjustified. In the case of P.N. Krishnalal versus Government of Kerala, this principle is stated to be entrenched in the Indian Constitution itself. Then the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, to which India is a signatory. They guarantee fundamental freedoms and fundamental rights to an accused persons. The procedure prescribed for trial must in spirit also stand the test of the rights guaranteed by these fundamental human rights. Then what about Section 101 of the Indian Evidence Act? The burden of proof that is given, prescribed under Section 109 would say that it reinforces the principle of presumption of innocence. Then we will be considering several parameters under which we will be justifying why and how the prisoner's right deserves some kind of protection. Prisons are built with the stones of law. You see the kind of language used, see the kind of thinking that has gone into the mind of those great thinking people. And then once they said it is a thick wall, now they say it is built of stones of law. If it is built up of stones of law, how can there be a violation? That is the question. The courts which send offenders into prison have an onerous duty to ensure that during detention, there is no breakage of law. In our world, prisons are still laboratories of torture, warehouses in which human commodities are sadistically kept and where spectrum of inmates change from driftwood juveniles to heroic dissenters. When I was reading this, I was just wondering, long time back when I read that, I was just wondering, how can there be juveniles inside the prison? Then there came a writ petition saying that under the Juvenile Justice Care and Protection Act, they cannot be kept in prisons, and jocularly the juvenile is kept in prison, therefore there must be a writ of habeas corpus to release him. As soon as the notice went to the other side, they took all steps to release the juvenile. Therefore this statement is very, very right. Whether inside or prison, outside the prison, a person shall not be deprived of his guaranteed freedom, save by methods that are right, just, and fair. This is the most important protection available under the procedural law. If the procedure adopted is not right, not just, and not fair, one is entitled to challenge that. Now you think of whether all the procedures that are adopted inside prison is right or just or fair. Originally, people were believing that only in police stations violations of human rights are happening, and only later they came to know that prisons are no better. There are several acts governing the rights of prisoners, starting with Indian Penal Code, Prison Act, Prisoners Act, Identification of Prisoners Act, Exchange of Prisoners, Transfer of Prisoners. There are too many enactments. At least the last one is Model Prison Manual 2016. These are all the laws governing the rights of the prisoners. But many of the rights that are governed are in 1860 and 1900. After the Constitution, where it guarantees the fundamental rights, all these enactments should have been reenacted, or those old laws must have been repealed, and they must be brought in tune with the constitutional spirit. And I think that is not happening. That is why we have to speak about these kind of laws. Apart from the Constitution and the national law, there are also international rules and standards governing the rights of prisoners. As I said already, there is International Covenant on Civil and Political Rights, Convention Against Torture and Other Cruel, Inhuman, Degrading Treatment or Punishment, Standard Minimum Rules for Treatment of Prisoners, Nelson Mandela Rules, Body of Principles for the Protection of All Persons under any form of detention or imprisonment, then Basic Principles for Treatment of Prisoners. These are all the international conventions. And then that is also a continuation that you can just go through. Then there are important guidelines mentioned in the model prison rules. To ensure the safety of women prisoners, there should be at least one women jail in each and every state. Enclosures for women prisoners should have all the requisite facilities with reference to their special needs such as pregnancy, childbirth, family care, health care, and rehabilitation. Female prisoners should be granted equal access to work, vocational training, and education. A register should be maintained in every place of imprisonment where details regarding women prisoners' identity, their reason for imprisonment, day and hour of their admission and release should be mentioned. No male prisoner shall be permitted to enter the female ward at any point of time. These are all the other procedural requirements that are mentioned in the model prison manual. I think they are all rules that will be appealing to any common man with a common sense. It is to protect them from any kind of sexual abuse, sexual violence, etc., etc. But it also details the rights and as well as the protection. The most important one are coming in the last 5, where they say, where the rules prescribe, when a woman prisoner is found or suspected to be pregnant at the time of admission or later, the lady medical officer shall report the fact to the superintendent and send a gynecological examination. Next is arrangement for temporary release will be made to enable a prisoner to deliver her child in hospital outside the prison. Birth in prison should be registered at the local birth registration office. It is not to be registered that the child was born in prison. That is most important part. That is why I am reading this completely. The birth should be outside the jail limits, and it must be registered at the local birth registration office. That should be the place of birth. The children up to the age of 6 years of age shall be admitted to prison with their mother if no other arrangement for keeping them with relatives or otherwise can be made. The children of women prisoners living in the prison shall be given proper education and recreational opportunities. I want your views on this class 13. Children up to, many of them prize this provision, saying that at least up to 6 years of age, a child is permitted to be with the mother, and without the mother, the child cannot exist. There may be mother feeding, etc., etc., and therefore, this is a very, very benevolent provision. There are other views also, on the contrary, saying that after the Juvenile Justice Care and Protection Act coming into force, at least, there, for no fault of the child should not be inside the prison along with the mother. There are two extreme views on that. What is your view on that? What is the justification for this class 13? Is it right or is it not right? or what? It should be amended or it should be repealed. So what? Some of you can give your comments in the comment box.
It will be detrimental to the children's growth if they have to be in prison with the mother after they grow.
Yes, even at the time of growing and after the growth also,
Exactly, ma'am.
the impression that is in the mind of the child will never go, and it will not be in the interest of the child, or it will not be in the interest of the nation to say that the child must be inside the prison. Then,
Because there will be a scar left in the mind of the child.
yes, very right, very rightly said. What
Thank you, ma'am. This is Bala.
yes.
Good evening, ma'am. Good evening,
Yes.
ma'am.
Yes, sir.
Actually, what I'm trying to say is that it will be creating a very negative and very negative psychological effect on the child if he is in prison along with his mother or father or anybody in the jail. It will be a very drastic negative thing for him,
Yes.
and it will not be able to be curtailed even in the future if anything is taken care of once he
Yes,
is
sir. Yes,
or she
sir.
is in the jail.
Very right, sir. Excellent. Very sensitive and sensible answer. I think this provision must be challenged before the court. You know, at the time of delivery, some kind of attention from the family members in terms of health care, in terms of personal help, and at least a few years after the delivery, the child must be only with the mother. What I would suggest is that they may be kept in home detention. Home detention may be prescribed for them, and both of them shall not be inside the prison at least for a few years. And wherever the child is able to be independent, then they may consider detaining the lady inside the prison. That is a different issue. At least for a few years, just a few weeks before the delivery and a few months or years after delivery, the lady should not be inside the prison. Especially the child should never be inside the prison.
I would suggest at least for a year the child should be and mother should be detained in a private home.
Yes, sir. Right, sir.
Yes.
The prison atmosphere should not be there, and the child should never feel that it was inside the prison at least on any
I
single day.
think one year is not enough. 1 year is not enough, sir. Because the tender year, the children should be with the mother, and the mother should be outside the prison. As correctly pointed out by Justice Madam, they can be kept in some home.
Because during the formative years of the child should grow in a healthy atmosphere to grow up.
Yes, sir. Yes, sir. Right, sir. Very right, sir.
Hello?
Then, no. Yes, ma'am.
This is Jyoti Hyderabad, ma'am. Very nice lecture we are hearing. Regarding the question regarding the 6 years child, whether it's those who do not have relatives to be left with the mother can be left with the mother. I have a small suggestion. Maybe the children who don't have any relatives except mother who is in the prison can be kept in a homemade or something like private schools which are taking care by the state government child for education, kept in the residential like of the government.
No, ma'am. There is no substitute for mother in the whole world. Mother is always a mother. Nobody can.
Yes, absolutely right, ma'am. Absolutely right.
My point is, both of them cannot be in the prison. They must be outside in a private home or a home arrest or home detention, whatever the name we call. Let them be out of the prison. Confinement limited to.
Sorry to interrupt, Justice ma'am. Actually, I just wanted to say, because the term jail, it is in itself, it is a very negative thing, and it is definitely going to create such a negative impact on the psyche of the child that he will not be able to come out of that thing, that negative image, and it will go along with him for the entire life.
Yes, you are talking
any psychological count.
If the judges are able to think about that, even in terms of terminology use, that will be fine, sir. What you say is right. I agree with you. Very right.
Thank you.
Then we'll move on. adequate health facilities shall be provided to the children of women prisoners. I have gone through several jail committee reports where they have invariably mentioned that excepting a glass of water, nothing is provided either to the mother or to the child. Every prisoner should receive food every day, prescribed time, etc., etc. These are all in paper only. Then adequate clothing, accommodation, etc., etc. Those feel are not important. Then we are moving to the specific rights. This case law relates to whether at the time of prisoner is having the visitor's time and somebody would be visiting, whether at that point of time there must be some kind of privacy. When the husband was visited by the wife, there was escorts standing nearby. Therefore, they are not in a position to speak privately. And then came the writ petition. This is a judgment of the Madurai bench of Madras High Court, where they have pointed out, man is a social animal. He needs a family as well as a society to live in. The man needs both to share his emotions and feelings. Being human beings, prisoners also would like to share their problems with the life partner as well as with the society. Just because they are termed as prisoners, their right to dignity cannot be deprived. This is a judgment where subsequently it was held that during the visitor's time, subject to the security issues, they may stand apart to a reasonable distance so that they will have the freedom to talk freely without the inhibition of the presence of somebody else. That is what is held there. Then the parole and furlough. There are two kinds. Parole, as we all know, it is a temporary release of prisoner before the expiry of the sentence. Then you are only in Bombay. I thought the system of furlough is there in no other state. I do not know if there is in any other state. Let me know. The Bombay prisons furlough and parole rules 1959 deals with both. Parole, temporary release from prison, is granted to a convict in an emergency such as death in a family or marriage or relatives. This is the very, very, very important provision. Furlough is generally given to a prisoner once in a year on certain conditions and criteria. To go on furlough, there need not be any reason like death, marriage, birth, schooling, purchase of property, etc., etc. We need not think of any idea at all. The very purpose of furlough is to give the connectivity between the prisoner and a family. Supposing there is a child in a family, a prisoner is inside the prison for years together. For reasons we all know, generally children are not brought to the jail premises. And then on a one fine day after 7 to 8 years, if the prisoner is going back, how the child will react, how the family will accept him, how he will be able to socialize within his own family. Keeping that in mind, this provision for furlough is available. I think only in the Bombay prison rules. I have not seen anywhere else. And the purpose and the principle of furlough and parole is described in this decision. It is now well settled that furlough and parole have two different purposes. Furlough is a matter of right, whereas parole cannot be claimed as a matter of right. Furlough is to be granted periodically under Rule 3 of the furlough rules, and the principal object of grant of furlough is to enable the prisoner to have family association and to avoid all ill effect of continuous prison life. See how beautifully it is written. The ill effects of continuous prison life is sought to be averted, and what is sought to be achieved is some kind of cohesion, some kind of understanding, and some kind of familiarity between all the members in the family along with the prisoner. While undergoing sentence according to furlough rules, a prisoner is accorded social interaction. Man being a social animal, social life is brought into existence periodically for a prisoner by providing furlough. However, there is an amended rule of the prisons under which prisoners convicted in crimes related to terrorist activities shall not be granted furlough. You see, where the necessity comes, they are making exceptions, and otherwise it is a very, very sensible provision. And just because there is no provision, it does not mean that it cannot be done. You can always very well argue that when a furlough is essential for a person for some kind of very basic reasonable reasons, and that should be extended to prisoners of other state also, that you can just think of. This is with reference to Tamil Nadu suspension of sentence rules, and where they have prescribed terms and conditions under which, circumstances under which the sentence can be suspended and they can be permitted to go on parole. It is special to Tamil Nadu, therefore I am not detailing it. Then emergency leave and ordinary leave. There are two kinds of divisions in that. Normally, emergency leave is granted only in serious reasons like death and all, and regular leave is granted under normal leave rules. Then the very interesting questions came before the Madras High Court. A person wanted to attend the 40th day ceremony of his father. He was not able to attend the death ceremony, therefore he said that at least for the 40th day, he must be permitted to go. The argument by the prosecution was only for death he can go and not for the ceremonies. That was the argument placed. And our justice in the Supreme Court at present, Honorable Justice Ramasubramaniam, it came before his lordship, and his lordship gave the interpretation for the word death, where he has distinguished between the funeral that is being attended to by the relatives on one side and the third parties and the intimate relations like mother, son, daughter. See the language, see the reasoning. The word death would certainly include within its fold the ceremonies that a person is obliged to perform if he happens to be a believer. Otherwise, if a plain and literal interpretation is given to the word death, even a father, mother, son, daughter, or brother would be able only to pay the last respect like a stranger to the family. The intention of Rule 6 cannot be understood to be reducing the role of the father, son, mother, and a daughter to that of a mere visitor paying the last respect to a departed soul. The prison authorities to allow the prisoner to attend the 40th day fatwa ceremony of the deceased mother. See, even if there are no rules, the humanity requires that these kind of request for 1 or 2 days, and that too, that will be having long lost impression upon the mind of the prisoners. Being inside the prison would give them some kind of irritation, and apart from that, even if this kind of reasonable request is not accommodated, then it is not going to reform them. If the ultimate object is reformation, we should be able to give at least some kind of this intermittent relief. That is what I would say. When it is relating to the death of the mother or father, especially, it is all the more important that these kind of requests normally should be accepted. Then when we talk about the rights of prisoners, and we also admit that there are violations inside the prison, what we are expected to do when we are talking about prisoners' rights? I think starting from arrest. Is it necessary for the police to arrest the persons in order to continue the investigation? That will be the first question. If the arrest is mandatory, if the arrest is indispensable, if the arrest is essential for investigation, then is there any justification, or whether if the FIR discloses a cognizable offense, only then the remand is justified? Maybe if even if the initial arrest is justified in the sense that in the opinion of the police it is necessary to arrest, whether the complaint given discloses the cognizable offense and the remand is justified. In other words, if the court is applying its mind to the facts stated therein in the first information report, and whether the court chooses to remand, whether the order is perfectly legal in accordance with the rules. These kind of initial precautions, not only that, and thereafter on the expiry of a particular period, statutory bail, Then during incarceration, it is right to fair and speedy trial. Those who are inside the prison are certainly entitled to preferential right to have the speedy trial. Those who are on bail also entitled to speedy trial, and those who are inside the prison must be given the priority to complete the trial, and they should have a right to ask for the court to take up their case in preference to other pending cases. These are all the rights that are available at various stages, and you as lawyers and law students, you should take care of each and every stage so that nobody is put behind the bars unnecessarily or unwarrantedly. Arnesh Kumar is the leading case on this subject, and a very important observation that I have extracted here. Lacks procedural affect the functioning of the state by creating cascading obstacle to the administration of justice that in turn generate huge backlogs and unnecessary appeals. That is why the court is expected to inquire and challenge the police in relation to the necessity of an arrest, the completeness and accuracy of investigations, the rationale for remand, and the custodial treatment of the accused. These are all the very important observations. We will see there are more important dictum that is laid down in Arnesh Kumar, which we will see at the end of this slide. Then I told you already that the conversation between the prisoner and the spouse should be unmonitored. This is one more case. Then this is a very, very important judgment relating to transfer of prisoners. It is a fundamental requirement that once a person is put inside the jail, and if it is going to be released after several years, there must be some kind of link between his family and the prisoner so that after release, the prisoner is not put under any embarrassment. And moreover, when a person is in the jail where he is familiar with the language that he can speak with a fellow prisoner, it would have some kind of ventilation for him to speak about. In these facilities are not available, then the prisoner will have every right to seek transfer of himself to a place which is closer to his family. That was a request made here, and the petitioner Radhakrishnan, who is a death row convict, he was allowed commutation of sentence by to a limited extent of from death penalty to life imprisonment. His 92-year-old mother wanted the prisoner to be transferred to Madurai Central Prison as Madurai is situated closer to her residence. The petitioner sought transfer on humanitarian grounds enumerated under Rule 568 of the Tamil Nadu Prison Rule. This was considered by the court, and the prisoner was ordered to be transferred. For anything and everything, there is a strong opposition, then the cases get stuck. What if a prisoner is transferred from one prison to other prisons unless there are extraordinary reasons for refusal? This transfer also was opposed, saying that this prisoner shall not be transferred because there are no rules. If the legislature cannot contemplate everything in advance, situations may come, or whatever is the situation that may come in the future, they can't think over. Even if they are able to think over and did not provide, does it mean that the persons have no rights at all? And see the mother aged 92. She may feel that she may die at any point of time, so that she may have frequent visit to his son in the jail. And the son also would be inclined to visit her more often because she is aged. These kind of small requests based on, even if there are no rules, these kind of matters to be considered on humanitarian basis. And if that is not even considered, then the prisoners will never get remanded. This is a case where the Honorable Supreme Court has pointed out that the laws need reforms in terms of the Constitution. The Supreme Court stated that the century-old Indian Prison Act 1894 needs a thorough look and is required to be replaced. See the language used. It is required to be replaced by a new enactment which would take care of the thinking of independent India. At that point of time, what was the position? And now the law should be in terms of the thinking of an independent India and our constitutional motion mandate. This single judgment is more than enough for all of you to challenge those provisions which are not in the interest of the human beings at all. It is not in the interest of the society. By inflicting cruelty, punishment, ill treatment, and humiliation to a prisoner, and once he is getting released, it will be more dangerous to the society. Therefore, in social interest, at least, we must be able to treat the prisoner in a better way. Then there is this Arnesh Kumar case is only with reference to this section 436A. I would like that each and every one of us should give the best attention to the provisions of section 436A, and the maximum utility should be taken out from 436A. We will be able to reduce the prison population, and the unnecessary and unwarranted imprisonment could be avoided if the provisions of section 436A is made use of. That is the why I have extracted the entire section. I think all of you would be familiar with that, so I'm not going to read that. And if a prisoner, not being a prisoner of an offense for which punishment of death or a specific punishment of death has been specified as one of the punishment, undergone detention up to a period of 1/2 of the maximum period of punishment specified for that offense, he shall be released by the court on his personal bond with or without sureties. And then, of course, the other formalities and the rules that are stated there. Only in the case of Bhim Singh versus Union of India, by the order dated 4/9/2014, a review mechanism was ordered to be set up by which the prisoners who have undergone more than half of the sentence would have been able to get the release from out of the jail. The 2005 Amendment Act on Criminal Procedure Code inserted section 436A to reduce undue delay of justice and overcrowding in prison. The under trial prisoners serving for more than half of the maximum sentence have the right to bail on personal bond. It is imperative that the under trials do not languish in jail longer than the maximum sentence under section 436A. This provision, however, does not address those under trials facing death sentence. Then the review mechanism provides for a composition of a committee. It shall be composed of the magistrate, chief judicial magistrate, and the sessions judge. The function is they shall hold one sitting every week in jail or prisons for 2 months, commencing from 1/10/2014. In the meetings, judicial officers will identify under trial prisoners who have spent half of the maximum sentence in jail and also provide an order for release in the jail. See the language used, they shall provide for an order of release in the jail. This is how the rights of prisoners were taken care of by the Honorable Supreme Court. But then they are also expected to put a report to Registrar General. There are other procedural matters. Then the same Arnesh Kumar, they took note of the fact, see the statistics. Crime in India, 2012 statistics published by National Crime Records Bureau, Ministry of Home Affairs show arrest of 1,97,762 persons all over India during the year 2012 for offences under section 498A of the Indian Penal Code. 9.4% more than the year 2011. Nearly a quarter of those arrested under those provisions were women, 47,951, which depicts that mothers and sisters of the husband were liberally included in their arrest net. Their share is 6% out of the total persons arrested under the crimes committed under Indian Penal Code. It accounts for 4.5% of the total crime committed under different sections of Indian Penal Code, more than any other crime excepting theft and hurt. The rate of charge sheeting in cases under section 498A is as high as 93.6%, while the conviction rate is 15%. I stop here. The charge sheeting is 93.6%, but the conviction rate is 15%. then the inference is that for rest of them, the imprisonment may be unnecessary. Maybe. I'm using the language maybe. I do not know. It is must be. Maybe for some reasons like not able to prove they might have come out. I do not know. But generally there is a complaint that in family matters, even when there is a maladjustment or mismatch or not being irretrievable breakdown, invariably they make use of or misuse of 498A. There is a general complaint about which we should have a separate session. But when the charge sheet is 93.6% and the conviction rate is only 15%, it is all the more necessary that the administration should be very careful in ensuring that these kind of provisions like 436A is implemented in letter and spirit. Otherwise, there is no purpose in saying that we have human rights and it shall be protected, it will remain protected. There are mandatory directions. These directions, they are before, there are directions before to be followed, which are before actual arrest of accused persons. And there are other directions which are to be followed after arrest. And I will not be detailing all those things, and I will only just read out the conclusions. The Apex Court put in bold concern raised by various benches over a period of time to bring the core issue of criminal justice to the center state and cautious law enforcing agencies that the power to arrest is to be used in a more responsible and logical manner. Number one is arrest is to be made in a more responsible and logical manner and not in a mechanical or insensitive manner. Because as the Supreme Court stated in this judgment, arrest brings humiliation, curtails freedom, and casts scars forever. Second is notice with reference to notice of appearance before police officers. The police officers shall, in all cases where the arrest of the accused person is not required under the provisions of subsection 1 of section 41, issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offence to appear before him or at such other place as may be specified in the notice. Where such a notice is issued, it shall be the duty of the person to comply with the terms of the notice. Where such person complies and continues to comply with the notice, he shall not be arrested in respect of the offence referred to in the notice unless, for reasons to be recorded, the police officer feels that he ought to have been arrested. These are all the kind of provisions, and that I will not say it is provision, it is a protection. In fact, it is an actual protection that is given to them. If police officer, whenever he chooses to arrest, he must record reasons why. He should also say why the arrest is imperative. And once he decides not to arrest, then the procedure to be followed is to issue a summons and to ensure that the summons person appears on account of the summons available. Then the more important thing is, if just go through these mandatory directions. But they are all very, very important directions. And if these directions are not complied with, then they can be brought to court very easily. Just for the sake of completion, I will just read out very important mandatory directions before arrest of an accused persons. In cases where the accused is exposed to imprisonment for a term which may be less than 7 years or which may extend to 7 years, with or without fine, existence of the following reasons is a precondition for arrest. Existence of following reasons. Police officer must satisfy himself that such person had committed the offence. Police officer before arrest has to be further satisfied that such arrest is necessary. Arrest is required for proper investigation. To prevent the accused from erasing the evidence of the offense, to prevent a tampering with evidence, to prevent such person from making any inducement, threat or promise, etc., unless such accused person is arrested, his presence in the court, whenever occurred, cannot be ensured. Apart from this, the police officer has to be satisfied whether arrest is necessary for one of the more of the purposes that is shown in section 41. Very importantly, Apex Court observed that above should be the facts-based conclusions to which a police officer must reach before effecting arrest. With that, I will share an experience that we had in jail visit during the period when I was the director of Judicial Academy. We had been to the jail along with the newly recruited magistrates, where an accused person stopped us asking these 3 questions. He was asking the purpose of visit. We explained to him that these magistrates should understand the purpose of the speedy trial as well as the prisoner's rights, and how the prisoner's rights is being observed in the jail, and what are the documents available in the jail to cross-check whether the rights available to the prisoners are ensured. He was telling that he was in prison for a period of 10 years and his case is likely to end an acquittal, as none of them have spoken about his involvement in the offense. And he was telling them that these at least new magistrates should understand the pain of those persons who are unnecessarily being detained for several years. His questions were this: I am suffering imprisonment for a period of 10 years. This is at a very, very productive time and productive age. What will happen to my family life when I am continuously in prison for a period of 10 years? I may not have a child if I get married after my release because I am aged. Second thing is, at the productive age, I have not put up my career option. My career is all out. I cannot get any government employment, this or that, even if I am getting acquitted. Number 3, who will compensate when you cry that, when you say that liberty is all the more important, liberty is a fundamental human right, freedom for which all of them fought and all of them rejoiced. What will happen to my freedom when I am in confinement for no fault of me? I was asking them how you are sure that he is going to be released. He said no evidence, absolutely no evidence against him, and the case is posted to judgment on the next day. These 3 questions he was bold enough, sensitive enough, sensible enough to ask. If these 3 questions may be inherent in all the cases, or in many cases also, we do not know. But therefore, it is our duty to ensure that the prisoners are also human beings. Prisoners also have fundamental rights. Prisoners' rights can be curtailed only in accordance with the procedure established by law under Article 21 of the Constitution, and not otherwise. The procedure and the treatment should be very fair, proper, and legal in terms of judgment in the Maneka Gandhi's case. If with this available mechanism and available law, why we are not able to protect those who are inside? There are umpteen number of issues to be spoken about regarding the juvenile home, shelter home. There are too many homes apart from these kind of jail. And those positions are very, very critical. Then this release of prisoners, which I thought I should talk about, is important because at this pandemic period where we suffer even at homes, when there is overcrowding in the jail, where is the question of social distancing for prisoners? Are prisoners born to die? If this kind of pandemic, and if fortunately the Supreme Court intervened and gave a lot of directions for their release, but how much is implemented, how much is not implemented, we do not know. Therefore, it is all the more necessary that we should have some kind of thinking for those invisible persons who feel that they are not heard of. Yes, there are legal aid provisions for visit of counsels to the prisons. And there are some legal aid clinics inside the prison also. But the grave mistake, the great mistake they make is they go and visit the prisoners along with some prison authorities, either the warden at the basic level or the superintendent, whoever it may be. I have seen many of them visiting along with the concerned persons in jail, who will have the freedom to tell their grievances. There must be some mechanism by which, without the scrutiny by the prison authorities, at least the District Legal Services Authority should be in a position to collect the grievances and address their reasonable grievances, ensure their freedom, and so that we will also have a claim that the fellow prisoners are also human beings. They are also our brothers and sisters. I think we should look into these aspects very seriously. Thank you very much for your patient hearing. Thank you very much.
Thank you very much for the wonderful presentation, madam. You have covered almost all the points that are very, very relevant in the present scenario. In fact, while you were rightly mentioning about the detainment facilities that are available in India, most of the detainment facilities that were made were actually for the reformative purpose. But on the reality, it is all making the individual actually to lose his identity when he comes out of the prison. In fact, this reformation is not seen in any prisons in India, and in fact, that person actually becomes a misfit when he actually comes out of the prison. He becomes a misfit in the society. So covered it in a very lucid manner, madam, and in fact, it is also very essential to maintain a cordial environment even in prison. After all, they are also human beings, and the human rights should not be violated. As you rightly mentioned about the international human rights that are playing a major role in the 21st century, that has actually shaped and reformed so many countries, and which they have also adapted in so many countries. Thank you very much, madam. Now, with your permission,
Yes.
shall we move on to the next segment, madam? It is APLC's APLC. We are having questions we have prepared from our end.
Yes, sir. Yes, sir.
Thank you, madam. Just to start on a breezy note, madam, looking back at your journey as a judge, if you are asked which one case has given you utmost satisfaction and which one case has given you sleepless nights, madam?
Very, very, very interesting question. Even with regard, if I say, if I am going to share with you one case relating to this prison reform itself, that will be quite informative as well as the interesting case for me. In cases where the one spouse get the life sentence or death, and the other spouse is the complainant, and what will happen to the life of the child? There was an appeal before my court, and I think several lawyers here in front of me argued those cases in an amicus curiae in the Madurai bench. The district judge, while passing the order, has considered that child as a child in need of care and protection, and wanted the authorities to produce the child before the child welfare committee, and from where the child was taken care of. When the matter came in appeal, I also appointed a committee. There was 8 prisons. I appointed a committee for each and every prison. All prisoners were inquired, and wherever cases in which the children were the victims and invisible victims, their case was taken up. They were produced before the respective child welfare committee, and their interests were taken care of. See, by a single judgment, we are able to identify those cases in which the help is needed for the child. We take care of the interest of the child by the single judgment. There are several judgments which we can tell, but it may not. We may not have time to share all those things.
Yes, madam. Thank you. Thank you very much for sharing this very interesting piece of information.
Hasini case also, it is our bench who confirmed the death sentence. The Dashwant case, the name of the accused is Dashwant, and Hasini is the child aged about 7. who was ravished by the neighbor in an apartment, and she was taken out and she was burnt to ashes. And ultimately, the CCTV camera got the clue that it is he who did it. And ultimately, he was sentenced to death by the trial court, and the confirmation came before our bench. And we gave our anxious considerations to both sides, not being carried away by the facts. Still, we had to confirm the death sentence.
Yes, madam. That is in fact a landmark judgment. Thank you very much for sharing this piece of information to our participants, madam. Dr. Justice, Dr. Lordship Vimala, tell to our participant one interesting side of the justice which most of our participants do not know.
Please repeat your question.
No, doctor, PhD in law, doctor,
yes,
doctorate.
Yes.
Justice Vimala, tell our participants one interesting fact about Justice Vimala which our participants do not know.
Whenever you ask me about this doctorate, I would say this doctorate I did it when I was a sitting judge of the Madras High Court. My interest is in child rights, and I came to know that before the Juvenile Justice Board, it is functioning like any other criminal court and not like the Juvenile Justice Board at all. The very purpose of the criminal justice system and the juvenile justice system are totally opposite. Why a particular person committed a crime is irrelevant in the criminal justice system, whereas in juvenile justice system, why a particular deviation occurred is the most important part of the question. But we can't blame the magistrates also, because in the morning they function as judicial magistrates, and immediately after lunch, one lunch is the interval. Lunch is the interval for them. Then immediately if they are asked to function like Juvenile Justice Board magistrates, then naturally we can't expect major changes in them. Like they are treated more like a criminal. The juveniles were also treated like that. That made me to take up a study on the functioning of Juvenile Justice Board in entire Tamil Nadu. I gave a finding that there is no procedural no compliance of procedural formalities, and it is the same as criminal justice system, and then there is no use of law. Juvenile Justice Care and Protection Act remains in static position. And after that, the High Court, at that point of time, the Honorable Chief Justice who conferred a PhD upon me wanted me to give the details. I gave them the details. And then they were in the Judicial Academy training. They were trained, one subject of psychology was introduced as one of the subjects by the Madras University, and thereafter there are several changes happening in the functioning of the Juvenile Justice Board. That is about my doctorate part of it.
Thank you, madam, for sharing this piece of information to our participants.
I think Advocate Adhumani and Advocate Narayanan are the amicus curiae in those cases. I think they are also online. I am able to see them, and they came as amicus curiae in those cases. In a case where the district judge wanted to produce the child before the Child Welfare Committee, we took up that issue, and the children of all prisoners were also taken care of. And generally, those who are, if advocates are conscious of the rights of the prisoners, only then court can interfere. In a prison adalat, 13 cases were reported to be settled, where the confined, only 200 prisoners only can be confined. One advocate by Karunanidhi issued a notice to RTI asking for details. Then the details discloses that only 200 prisoners can be confined. Then how came the disposal of 418? Then it came to notice that on a previous day they got arrested. See the kind of things that are being done. Very, very sensible lawyers are the protectors of the society. That is what I want to make it. Yes, sir. Any other questions, sir?
Thank you, madam. Thank you. Moving on to the next question. Prisons
Yes,
are
sir.
usually covered. Prison is covered under item 4 under the state list in the schedule 7th schedule of the Constitution, madam. The administration and management of prisons fall entirely under the purview of the state government. Do you think if the same is covered in the concurrent list or in the union list, there might be uniformity in the maintenance and upkeep of the prisons, madam?
Yeah, quite possible if reasonable decisions are taken at the central level also. It's a good suggestion. Wherever possible, there can be uniformity can be maintained. For a special requirement, the state can have their own rules. Very well thought over questions.
Madam, moving on to the next question.
Yes, sir.
Overcrowding of prison is one of the major problems which you covered during your presentation.
Yes, sir.
At the same time, the same prisons are being shared by the convicts as well as the under trial prisoners. So is it correct or is it wrong, madam, to actually mix the under trial prisoners with the convicts?
Yes, sir. It is a fact. It is a factual aspect that is covered in several reports also, that the convicts are mixed with under trial prisoners. This should be the first thing to be avoided in prisons. At no circumstance the under trial prisoners should be allowed to be mixed with the convict prisoners. It is true that there is overcrowding in the jail invariably in several places in Indian prisons. Then it is time for us to think of open air prisons and keeping the prisoners outside the, maybe inside the compound, but outside the jail walls. Open air prisons we can consider and think of so that they can be productively engaged in some kind of work or leading. Many prisoners are now PhD holders doing master's degree. There are several prisoners in Furlough jail in Chennai I have seen, where they are all showing great keen and great interest in studying. Probably if they are channelized, they can do better.
Yes, madam. Thank you. Thank you very much, madam. Madam, do you think there is a role of media and press in maintaining or changing the mindset of the people? Because mostly media, they are considering the person as guilt until proven innocent, which is contrary to our basic presumption. So what do you think, madam?
Definitely, sir. Definitely, they have a role, and their role should only be positive and not negative. They can really play a very critical positive role that we expect them to play.
Yes, madam. Do you think the legal aid will come to the rescue of the prisoners and under trial prisoners if there is a major shift in the work taken up by the NGOs and other organizations, madam? The involvement of them.
Our district legal services authority is functioning very well. And if the NGOs are going to support the activities of District Legal Services Authority or Taluk Legal Services Authority or even the State Legal Services Authority, that will be wonderful. And there are two kinds of facilities that is given by the District and Taluk Legal Services. Those councils, they can visit the jail and find out the legal requirement, and whomsoever want bail or any civil matter problems, they can very well assist. And even at the time of remand, some duty councils are assigned their job. They will be present throughout the day. And if a person is produced for demand, they will ask them whether they require any legal aid from the legal assistance from the lawyers deputed by the Legal Services Committee and all. These kind of protection is now given by the Legal Services Authority.
Thank you very much, madam, for the clarification. Now, just for the want of time, we cannot miss this opportunity of hosting you. We will just have this segment called Rapid Fire, madam. We will just ask you a few questions. Kindly answer it in for us, madam.
You want me to fill up the gap?
Yes, madam. So one person you looked up as a role model during your younger days.
Younger days, my father.
Yes, madam. Thank you. One act which needs complete changeover.
Complete changeover. It is only the Prison Act.
Thank you, madam. Do you think in reality there is actually judicial overreach as mentioned by the media?
Very rarely, sir. Right interventions at right time and the right context only we interfere. But maybe at times, maybe out of concern for the society, some few percentage of overreach.
Thank you. Power or money? Which one induces a person to commit wrong in the society, madam?
Power and money are both sides of the same coin.
Yes,
Both.
madam.
Both.
Thank you, madam. Do you think repeated offenders also need a chance to be given to rectify their ways, madam?
Definitely, sir, definitely. Only thing is we have to find out why he is repeatedly doing despite the sentence undergone. Only thing is further and deep investigation will be required, and he is also a human being. Anybody is liable to be corrected. Anybody is amenable for correction. Only thing is we should adopt a proper strategy and appropriate method for correction. That's all. He is also amenable for correction.
Thank you, madam. How important is our outlook towards the society, especially those who are actually coming out of the prisons? How do we need to treat them, madam? How do we need to treat them?
We should treat them as a person in need of some help, not as a person who has committed some mistakes. That is a basic outlook one should have, so that they will feel comfortable to mingle with us. Otherwise, their life will be very difficult.
Yes, madam. Do you think the judicial system that was there during the start of our independent India has evolved for the good, or it has changed, madam, completely?
I think the lawyers are the judges of judges, and you should answer that question now. What is your view about? Because I belong to judiciary, it is not for me to tell that. You as lawyers using the justice delivery system should tell me how do you feel about that.
No, we are not competent enough to actually answer the question, madam.
No,
Thank you, madam. Yes, madam. Yes, please.
Yes,
madam,
sir.
One line which you would like to tell whether winning a case means success in life.
Sir, that exactly is pertaining to family court cases, not for all cases. That will start with the family court matters. In family court matters, they believe that they are fighting tooth and nail with the person, ultimately to ask for reunion, or ultimately to realize that they have fought out a wrong case, or they have not done a right thing. And maybe say if they are obtaining a divorce, they may feel happy on the day when the judgment is pronounced. The reflection will come on the very next day morning. The child will ask immediately from the bed, where is the father? There is no answer. If it is with the father, if the child is going to ask, where is the mother? We feel that we are defeated. Therefore, it is better to get the matters resolved by alternate dispute resolution methods in family matters especially, and not to fight in an uncivilized way like an opponent, and then to feel for the rest of the life. It should not be done. That is a message that is given in that book.
Yes, thank you, madam. And last question, for the benefit of our participants, please share your success mantra, madam, for our participants.
Success mantra. I have learnt from lawyers, and wherever possible, I made myself my stand very clear to the lawyers. That is my way of open court functioning itself. The success mantra is nothing more than reading at all times, wherever possible, whenever possible, in a very meaningful way, in a deep way. That is judicial understanding, or understanding by legal fraternity, requires reading in between lines, not a mere reading of textbook. Reading the mind of the people, reading the textbooks, reading the society, reading the way in which the whole world is moving. That is very, very important to get success in life. And if that is followed, and I think success will come automatically.
Thank you, madam. You have been a role model for us throughout your career. We have looked up to you as an inspiration. And even if we try to emulate 10% of whatever success you have achieved, definitely we will be very successful in our career, madam. We thank you from the bottom of our heart for coming on board for such a small organization like ours, and giving your valuable information, madam.
Sir, you are in the process of dissemination of knowledge, and even at times of COVID, you have given an opportunity for all of us to think over something in a leisurely manner and to communicate with each other so that each and every one of us remain benefited. Thank you very much for the opportunity given, sir. Thank you.
Thank you very much,
Thank
Madam.
you.
It was really good. And thank you very much all the participants for this attending our 24th webinar. We are having other exciting webinars as well. On Sunday, we are having the 25th session. Kindly keep a tab on our YouTube page and Facebook page for more updates. Those who have not subscribed to our YouTube channel, kindly subscribe to our YouTube channel to be the first person to receive all the updates on our latest videos. With this, I thank each and every one of you for coming on board and gracing us on this occasion. I take this opportunity to once again thank our special speaker, Madam Justice, for coming on board. And with this, it is Anand signing off. Thank you all. Have a great week. Jai Hind.
Thank you, sir.
Thank you, sir.